Donald Trump just announced that he is now not going to testify at his New York civil trial tomorrow. Just moments ago, in a long, rambling Truth Social sentiment, Trump said, quote, "I have already testified to everything and have nothing more to say other than that this is a complete and total election interference Biden campaign witch hunt that will do nothing but keep businesses out of New York. I will not be testifying on Monday." That from the former president. So for days, though, Trump had vowed that he would be retaking the witness stand tomorrow in the high-stakes trial that threatens his real estate business. New York Attorney General Letitia James is suing Trump for $250 million and seeking to bar him from doing business in the state. CNN's Zachary Cohen joining us now. Zach, what more do we know about this, sudden change of heart?
Yeah, Fred, clearly a reversal here from Donald Trump, who had seemed adamant that he wanted to take the stand for a second time in this New York civil trial. Now, as you mentioned, posting on Truth Social just moments ago that,
"Hey everyone, John here, and we're rolling again." After exhausting every appeal, the New York court system delivered a unanimous verdict. Trump must sit down and answer questions under oath like everyone else. The moment his legal team had fought tooth and nail to prevent had finally arrived. That systematic rejection of every legal maneuver Trump attempted to avoid sworn testimony stands as one of the most significant moments in the entire saga of his legal battles. Not because it involved criminal charges, but because it was about something far more fundamental. It was about the basic legal principle that when a law enforcement authority is investigating potential financial fraud and you are at the center of it, you can be compelled to sit down and answer questions. The fact that you are famous and powerful does not create an exemption. The fact that there might also be a criminal investigation does not shield you from civil questioning.
he will not be testifying. In all caps, he says, will not be testifying on Monday. He goes on to continue to attack prosecutors and the judge in this case, calling it election interference, witch hunt, some familiar terms and familiar attacks that we've seen from Trump, not only in this case, but in others. But I want to play some sound from Trump's lawyer, Lena Haba, from just the other day when she said that lawyers had advised Trump not to take the stand again, but that he was adamant about doing so anyway. Listen to what she said to reporters just a few days ago.
He still wants to take the stand, even though my advice is at this point, you should never take the stand with a gag order. But he is so firmly against what is happening in this court and so firmly for the old America that we know, not this America, that he will take that stand on Monday. He will open himself up to whatever they want because he's not afraid. People that are afraid cower. President Trump doesn't cower. We'll be back on Monday.
President Trump doesn't cower. That was what she said about his willingness and desire to testify again. But just this afternoon, Trump walking that back, clearly, saying that he's already testified and that he has no reason to take the stand again. So an interesting kind of comparison there between the statement from Trump's lawyer a few days ago and now this decision to
the courts, from the trial level to the appellate division to the state's highest court, were not going to give Trump special treatment just because of who he was. Every appeal got rejected. Every constitutional argument got dismissed. And eventually, Trump had to sit in a chair and face the questions he had spent years trying to avoid. What happened in that room and in the civil fraud case that followed is exactly what the judges who ordered the testimony were intending to make possible. The complete legal sequence deserves careful examination because the systematic nature of the rejection, how every level of the court system said no to Trump's arguments, one after another, is what makes this story so significant. It started with Judge Arthur Engoron in the trial court.
No longer testify on Monday in the New York civil case.
Yeah, interesting indeed. All right, Zach Cohen, thank you so much. Tell us if you learn anything more. All right, right now, joining me to talk more about this is Harry Litman. He is a former U.S. attorney and a former deputy assistant attorney general. Great to see you, Harry. So your reaction to Trump's decision to no longer take the stand tomorrow?
Yeah, I wasn't particularly surprised. I'd always thought that was kind of posturing and that he might well back down at the event. It's the smarter legal move. He's got very little to gain. He would probably have taken the stand and given the same kind of infomercial that Donald Trump Jr. gave, but it wouldn't have gone to the evidence. And most dangerously, he would have faced cross-examination, which is, the rules really permit a probing yes or no set of answers, and that could have put him in hot water for either having to tell the truth or commit perjury. So this is a case that he already realizes he's going to lose. And the only value, when it goes up on appeal, they're going to ask.
The New York Attorney General's office, led by Letitia James, had been conducting a civil investigation into the Trump Organization's business practices, specifically into allegations that Trump and his organization had been inflating asset values to get better loan terms and deflating them for tax purposes. That investigation generated subpoenas, legal demands for Trump, his eldest son, Donald Trump Jr., and his eldest daughter, Ivanka Trump, to appear for sworn depositions and answer questions about what they knew about how the organization's assets were being valued. Trump's legal team fought those subpoenas aggressively, employing every argument they could devise.
Did the judge below have enough there to say he was guilty? And whatever he might have added on his side of the ledger wouldn't really affect it anyway. Plus, he has really nothing to say, I think, other than the magnificence of his empire and the like, and that wasn't going to impress the judge at all.
Yeah, so perhaps the prosecution was really looking forward to him taking the stand again tomorrow because, there might be a misstep. That cross-examination moment could be pivotal for them. So then now, how does the prosecution redirect, if it even needs to, since he is no longer making himself available in the morning?
Yeah, you're certainly right. They knew he might have been faking, but somebody's been staying up all weekend with, constructing very, very surgical questions. Now what happens? The prosecution has a couple, we're told, pretty ministerial, quick work witnesses. And then it goes to the judge, who will probably ask each side for what the lawyers call conclusions of law and statements of fact.
They argued that because there was also a parallel criminal investigation being conducted by the Manhattan District Attorney's Office, being compelled to testify in a civil proceeding would violate their Fifth Amendment rights against self-incrimination. It was a creative legal argument, one that had surface appeal. If a civil deposition could generate answers that might later be used in a criminal prosecution, then being compelled to give that civil testimony creates exactly the kind of self-incrimination pressure that the Fifth Amendment is supposed to protect against. Judge Engoron rejected the argument firmly and directly. He found that the Attorney General had the clear right to compel the depositions, that the existence of a parallel criminal investigation did not create an automatic shield against civil discovery, and that if Trump and his children wanted to protect themselves from self-incrimination,
and he'll choose among them, and within about 3 weeks or so, I think a blistering shellacking of Trump and company will emerge from the judge, and then it will go up on appeal. But I think that's what we can now expect. And I think, a couple of days from now, all the evidence will be in.
So those statements of fact, that would be like a closing argument, something you'd see in another kind of trial, like a criminal trial, for example. But since this is a civil fraud, you're talking about the statement of fact that the judge will then review before rendering a decision on paying up.
That's exactly right. Each side gets to say, here are the facts that the evidence shows. Here are the conclusions of law, and those are the building blocks of his eventual decision. They will be night and day, believe me, in difference from Trump's team and the AG, and you can expect him to mainly go with the AG. But it's customary for him to give each side a sort of shot at submitting those.
Okay. Harry Littman, great to see you. Thanks so much for that breakdown.
Thanks, Fred.
they could invoke the Fifth Amendment on specific questions during the deposition itself. What they could not do was use the existence of the criminal probe to avoid the deposition entirely. That ruling was the first in a series of judicial doors closing on Trump's ability to avoid sworn testimony. Trump appealed immediately. His legal team took the case to the appellate division, where a 4-judge panel reviewed Engoron's order. On May 25th of 2022, that panel issued its decision. 4 judges, all 4 agreeing, upholding Engoron's order, and rejecting Trump's appeal. The panel's ruling was clear and direct about why the parallel criminal investigation argument failed. Civil discovery and criminal investigations operate on different legal tracks entirely. The existence of one does not automatically suspend the other. The proper mechanism for protecting Fifth Amendment rights in a civil deposition is to invoke the Fifth on specific questions, not to refuse to appear at all. Trump could show up and decline to answer specific questions that he believed would incriminate him. What he could not do was refuse to appear entirely. The appellate division was firm on this point, and its firmness meant that Trump's argument, which had been his strongest legal defense against the depositions, had now failed at 2 levels of the court system. That sent him to the highest court in New York. Now let us talk about what happened at New York's Court of Appeals, the state's highest judicial body. The way the Court of Appeals disposed of Trump's final attempt to block the testimony is itself remarkable for its brevity and its dismissiveness. The court did not grant extensive briefing, it did not schedule oral argument, it did not issue a lengthy opinion addressing Trump's constitutional arguments in detail. It dismissed his motion to stay the subpoenas as academic, meaning the issues he was raising were no longer live or relevant enough to warrant the court's intervention. And it said in language that is about as concise as high court dismissals get, that there was no substantial constitutional question presented. No substantial constitutional question from New York's highest court about arguments that Trump's lawyers had been presenting as fundamental protections of his constitutional rights. The highest court in the state looked at those arguments and concluded they did not rise to the level of a substantial constitutional question. That dismissal, brief, direct, unambiguous, killed Trump's last appeal and cleared the way for the depositions to proceed. Now let us talk about what the no-win situation that resulted actually looked like for Trump and his children, because the courts ordering them to appear for depositions put them in exactly the position that Trump's legal team had been fighting. So, hard to avoid. Understanding that no-win quality helps you understand why the fight to block the depositions was so fierce in the first place. The dilemma was straightforward and brutal. If Trump and his children showed up and answered questions under oath about the Trump Organization's asset valuations, about the specific claims that the Attorney General was investigating, their answers would become evidence in the civil case, yes, but potentially also feeding into the criminal investigation running in parallel. Anything they said under oath about what they knew, when they knew it, and what they approved would be on the record, would be available to prosecutors, would be subject to perjury consequences if they were not truthful. And the questions would be about exactly the topics where the most damaging answers were possible. Inflated valuations, deflated taxes, what the principals of the organization knew about how the numbers were being presented. Those are not comfortable questions for people who are targets of a fraud investigation. On the other hand, if Trump and his children showed up and invoked the Fifth Amendment, repeatedly declining to answer questions on the grounds of potential self-incrimination, the legal protection would be real, but the optics would be devastating. There is no good look associated with a prominent business person sitting across from investigators and repeatedly saying the words, "I decline to answer on Fifth Amendment grounds." It does not establish guilt in a legal sense, but in the court of public opinion, and for a political figure who presents himself as having nothing to hide and having run a great business, repeated Fifth Amendment invocations are a reputational catastrophe. That is the no-win dilemma. Give prosecutors ammunition or stay silent and look guilty to everyone watching. Now let us talk about what Trump actually did when the deposition finally happened. Because what he chose to do in that room after all the legal fighting, after all the appeals, after the state's highest court dismissed his last argument, tells you something important about his assessment of his own legal and political situation. Trump invoked the Fifth Amendment repeatedly. According to reporting on the deposition, Trump declined to answer questions on Fifth Amendment grounds hundreds of times, not once or twice on specific sensitive topics, but hundreds of times across a broad range of questions about his business practices and his knowledge of how the Trump Organization operated. That decision to invoke the Fifth Amendment hundreds of times, rather than answer questions about his business record under oath, reflects a specific judgment about the legal risk of honest answers to those questions. People invoke the Fifth Amendment because they believe honest answers to the questions being asked could incriminate them. That is what the protection is for. And the scale of Trump's invocation The breadth of the questions he declined to answer gives you a picture of how extensive the legal exposure he was trying to protect himself from actually was in a legal sense. Those invocations cannot be used against him in a criminal case. But in the civil context, and particularly in how the judge and the public received the testimony, the hundreds of Fifth Amendment invocations were themselves significant evidence about how Trump assessed his own conduct. Let us also talk about how this deposition fight connects to the civil fraud case that followed, because the testimony battle and the investigation that generated it was not an isolated event. It was part of a process that culminated in one of the most significant civil legal judgments ever issued against an individual in American history, the New York Attorney General civil fraud case, the one that eventually produced a judgment of nearly $500 million before the appeals court reduced it, was built on years of investigation that included the compelled testimony of Trump and his children. The asset valuation questions that form the core of the civil fraud case are exactly the questions that the depositions were designed to address. Whether Trump and his organization knowingly inflated the value of properties to get better loans and deflated them for tax purposes. Whether the people at the top of the organization knew about and approved the practices that prosecutors were characterizing as fraud. The depositions were a vehicle for getting sworn answers to those questions on the record. And the civil fraud trial that followed and the judgment that emerged from it drew on the full investigative record that the compelled testimony helped build. The fight to block the depositions was, in that sense, a fight to prevent the building of a prosecutorial record that would later support a fraud finding, and the failure of that fight, the systematic rejection of every appeal, contributed directly to the conditions that made the civil fraud judgment possible. Now, let us also think about what the pattern of rejected appeals reveals about the quality of Trump's legal arguments in this specific context. The legal team that represented Trump in this fight was not inexperienced or incompetent. These were lawyers who understood constitutional law and who made what they believed were their strongest arguments at every level. And those arguments were rejected at the trial court level, at the appellate division, and at the Court of Appeals in ways that suggest the courts found the legal merits of the arguments insufficient rather than simply deciding against Trump on policy grounds. The parallel criminal investigation argument was creative but ultimately unpersuasive. The courts found that the proper mechanism for Fifth Amendment protection in a civil deposition is invocation on specific questions, not blanket refusal to appear. That is a straightforward and legally sound conclusion. And the Court of Appeals' determination that there was no substantial constitutional question suggests that even the state's highest court did not find the constitutional arguments to be close calls that warranted extended consideration. The arguments were rejected on their merits. The courts were not making a political decision to target Trump. They were applying standard civil discovery principles to a standard, if high profile, civil investigation. And those principles, consistently applied, led to the conclusion that Trump and his children had to appear and answer questions or invoke the Fifth on specific matters. Let us also think about what the deposition fight reveals about the broader legal strategy of delay and obstruction that has characterized Trump's approach to legal accountability. This specific fight appeals at every level. Last-ditch attempts to avoid sworn testimony, exhausting every available procedural option before finally being compelled to appear, is a template that appears repeatedly across Trump's legal history. The fight to block the Manhattan DA from getting tax returns. The fights over document subpoenas. The fights over executive privilege in the January 6th context. The fights over document retention in the classified documents case. At every turn, the strategy has been the same. Exhaust every procedural option available, delay as long as possible, never voluntarily provide what is being sought. That strategy serves multiple purposes simultaneously. It runs out the clock and buys time. It generates legal fees for the other side that may be difficult to sustain. It creates the impression of fighting back and not rolling over. And in some cases, it actually produces favorable outcomes. Appeals that succeed, subpoenas that get quashed, cases that get dismissed on procedural grounds, but it also has costs. It creates a documented record of obstruction and delay that prosecutors can point to as evidence of consciousness of guilt. It burns through legal resources. And ultimately, as the New York testimony fight demonstrates, it does not always succeed. Courts can and do reject every appeal and compel compliance. And when that happens, the delay strategy has simply delayed the inevitable while building a more extensive obstruction record. The systematic rejection of every appeal was a significant institutional statement about equal justice under law. From Judge Engoron's trial court ruling to the 4-judge appellate panel to the Court of Appeals dismissal, every level of the New York court system rejected Trump's attempts to avoid sworn testimony on the same grounds. The courts applied standard civil discovery principles to a high-profile subject and reached the same conclusion that those principles produce when applied to anyone else. The Attorney General had the clear right to compel testimony. The parallel criminal investigation did not create an automatic blanket shield, and the constitutional arguments Trump's lawyers raised did not amount to a substantial constitutional question worthy of the highest court's extended consideration. That consistency across multiple levels of the court system is itself a statement that the legal principles being applied are sound and are being applied uniformly rather than in a politically targeted way. The no-win dilemma created by compelled testimony is exactly what civil fraud investigations are designed to create. The design of civil discovery and fraud investigations is specifically intended to compel subjects to choose between answering questions under oath with all the perjury and criminal exposure that creates and invoking the Fifth Amendment with all the reputational and public perception consequences that creates. That design is not a flaw, it is the point. When someone may have engaged in financial fraud, the justice system creates the conditions under which they must either explain their conduct under oath or publicly invoke the constitutional protection against self-incrimination. Both choices generate information. Testimony under oath generates a record that can be evaluated for accuracy and that can be used in subsequent proceedings. Invocations of the Fifth generate an inference, not a legal finding of guilt, but a reasonable inference that honest answers to the questions being declined would be damaging. Trump's hundreds of Fifth Amendment invocations at the deposition generated exactly that inference in the context of the civil fraud investigation. The deposition fight and its outcome contributed directly to the conditions that made the civil fraud judgment possible. The Attorney General's investigation, which compelled testimony, was designed to support what eventually culminated in a civil fraud case that produced a finding of persistent and repeated fraud by the Trump Organization and a judgment of nearly $500 million before appeals court adjustment. The testimony battle was not an isolated legal skirmish. It was part of a sustained investigative process that built the evidentiary record for one of the most significant civil fraud judgments in American history. Understanding the deposition fight as a component of that larger process rather than as a standalone event gives you a clearer picture of why the fight to block the testimony was so intense. The stakes were enormous, and the court's rejection of every attempt to block the testimony helped to make possible the investigation's ultimate reach. The pattern of exhausting every procedural option before complying is a documented Trump legal strategy with documented costs and limits. The testimony fight follows the same template as multiple other Trump legal battles. Appeal everything, delay as long as possible, never voluntarily comply. That strategy sometimes succeeds, sometimes it runs out the clock, sometimes it gets cases dismissed on procedural grounds. But sometimes, as in the testimony case, it fails at every level, and the only result is a longer delay before the inevitable compliance. And in the process, it builds a record of the effort to avoid accountability that becomes part of the overall legal picture that prosecutors and courts evaluate when assessing the broader pattern of conduct. The systematic rejection of every appeal in the testimony case is a data point in that pattern. Understanding it as part of a pattern rather than as an isolated legal fight gives you the most accurate picture of what it means for the ongoing accountability story that surrounds Trump's legal and political career. The broader constitutional significance of what the New York courts established through this testimony fight cannot be overstated. The question of whether a prominent political figure, a former president, a current political candidate, a person with enormous resources, and an aggressive legal team can be compelled to testify under oath in a civil fraud investigation is not just a question about Trump. It is a question about whether the principle of equal justice under law has real meaning, or whether it is an aspiration that breaks down when the subject of investigation has sufficient power and resources to resist. The court's answer at every level, consistently based on standard legal principles, was that the principle has real meaning, that the Attorney General had the clear right to compel testimony, that constitutional protections against self-incrimination can be invoked on specific questions, but do not create a blanket shield against appearing at all, that the existence of a parallel criminal investigation does not suspend civil discovery, and that the state's highest court found no substantial constitutional question in Trump's last-ditch arguments. Those answers, repeated at every judicial level, establish a precedent that applies beyond Trump. They establish that no one, regardless of fame, wealth, or political significance, can use the legal system's procedural options to indefinitely avoid sworn testimony in a properly authorized civil investigation. That precedent will matter for future investigations of future powerful people. And it was established here, in this specific fight, by this specific sequence of rulings that systematically rejected every argument Trump made for why he should be exempt from the normal rules of civil discovery. The compelled testimony in New York tells us something important about the limits of legal resourcefulness when the underlying legal principles are clear. Trump's legal team was not without resources. They were experienced lawyers making arguments they believed in. And the arguments they made about the parallel criminal investigation, about Fifth Amendment rights, about constitutional protections were not frivolous. They were the best available arguments for the position they were trying to defend. And they failed at every level because the underlying legal principles that civil discovery operates independently of criminal investigation. That Fifth Amendment invocation on specific questions is the appropriate mechanism for protecting against self-incrimination in a civil context. That a blanket refusal to appear is not constitutionally protected, are clear and well established. When the underlying principles are clear and the facts of the case are straightforward in their application to those principles, legal resourcefulness can delay, but it cannot prevent the outcome that the principles dictate. The New York testimony fight is a demonstration of that limit. Resources and experienced lawyers extended the fight for months through the appellate process. But ultimately, the principles prevailed, and Trump sat in the deposition chair and invoked the Fifth Amendment hundreds of times, instead of answering questions about how his organization valued its assets. The hundreds of times Trump invoked the Fifth Amendment at the deposition, the breadth and the consistency of his refusals to answer questions under oath about his business practices is itself a piece of information that sits in the record of this investigation. Not legally dispositive in a criminal context, but significant as a documented response to civil questioning about the specific matters that were at the heart of the fraud allegations. When someone invokes the Fifth hundreds of times in response to questions about their own business records, the inference that those honest answers would be damaging is one that observers are entitled to draw. Trump's campaign and his defenders will characterize those invocations as a standard legal protection being exercised appropriately. That characterization is legally accurate, but politically and reputationally costly. And the reputational cost. The documented image of a prominent business person declining to answer hundreds of questions under oath about his own business practices is part of the legacy of the New York testimony fight that will remain in the public record regardless of how any specific case ultimately resolves. The courts ordered the testimony, Trump appeared. And what he did when he sat down hundreds of invocations of the Fifth is itself one of the most significant pieces of the documented accountability story that continues to unfold.